Hi. It's been a long time since I did a video. A lot of things have been going on, so consequently, I spent my time trying to fight Wells Fargo instead of talking to you in a video. And I hate videos that start out with lots of chatter. Okay, the reason I'm doing this video is that despite the law that the New Mexico Supreme Court wrote itself in Deutsche v. Johnston, in which I've quoted for ages in fighting Wells Fargo, they decided against me. Even though the law, per that case law, Deutsche v. Johnston, is entirely on my side, for whatever reason, for whatever reason, they chose to not go with their own case law. Okay, so this is what my motion for rehearing video, no, I'm making a mistake, sorry. Okay, this is what my brief in support of motion for rehearing says, and I want you to hear this. The reason I'm doing this video is so that you hear what the problem is that I think is causing so many Americans to have their homes taken by banks and transferred from private ownership to corporate ownership. So listen to this and see what you think. Okay, so brief in support of motion for rehearing. Comes now Karen M. Klein, pursuant to Rule 12-404, and files her brief in support of her motion for rehearing. Okay. Core point. Concurring contradicts Deutsche. The appeals court contradicted Deutsche v. Johnston 369 P.39 1046 2016 when it wrote, "We find no error in the fact that the plaintiff proved standing by establishing its entitlement to enforce a lost instrument by way of evidence at trial." Sounds good, doesn't it? Okay, but page 5, memorandum opinion. The contradiction lies in the appeals court approving the use of two UCC statutory categories, with the second not being stated at the commencement of the case, whereas Deutsche specifically says, paragraph 14, okay, I've got to scroll up so I can read the rest of it. Just a second. Okay, so you've seen my ceiling, I would take it. Okay, to show a direct and concrete injury, this is what paragraph 14 says the New Mexico Supreme Court wrote. To show a direct and concrete injury, Deutsche Bank needed to establish that it fell into one of these three statutory categories that would establish both its right to enforce homeowners' promissory note and its basis for claiming that it suffered a direct injury from homeowners' alleged default on the note. And I added bold added because one is bold so that they see one. Okay, so then I go on. Wells Fargo filed its complaint for foreclosure, I've got to breathe, as if it fell into the statutory category of holding the note, indicated by the copy of the note attached to its complaint, filed in 2008. However, the note had in fact been lost in 2002, according to Wells Fargo's business records and the testimony at trial of its witness, Brooke Bozier. Okay, next paragraph. Just a minute. I have to scroll again. Maybe I can do it more quickly. Given the existence of the fact that the note was lost in 2002, Wells Fargo needed to have chosen the lost note category in order to have established standing at the time it filed foreclosure. Under Deutsche, Wells Fargo is not allowed a second category within the same case, whether Wells Fargo can prove that second category at trial or not. Okay. Okay. At commencement of the case, Wells Fargo chose one statutory category, as requested under Deutsche. But Wells Fargo chose the category of holder of the note when Wells Fargo was not holding the note. As a result, Wells Fargo failed to establish standing. Without standing, Wells Fargo could not go on to change its category or add the category of lost note, not even by amending its complaint, as defendant me argued when Wells Fargo moved for leave to file an amended complaint. Got to scroll again. Okay. I'm reading more than I thought I would, but I want you to understand that this is case law which was quoted by Supreme Courts in many other states. And yet here in New Mexico, when a New Mexican me, I've lived here since a long time. I moved here in the 60s, but then I lived in London for 9 years and I moved back. So when a New Mexican, effectively me, wants to use the law, no, we've got to let Wells Fargo have your home because Warren Buffett, gets 10%. He only pays 10% tax, but he's got to make his earnings. He's got to make his living off your home. Okay, so I'm obviously a bit upset. Okay, then I have a new heading, definition of one. The definition of one can be as a single thing or a member of a group. If one means a member of a group, I don't know if that means that one could be a succession of members. If so, then that may be how the appeals court read it. However, if a succession of categories is what the New Mexico Supreme Court meant, then the court would not have gone on to write. Okay, I've got to scroll again because this paragraph is long. Paragraph 27 of the New Mexico Supreme Court's Deutsche. However, this is an issue, this is the Supreme Court has written this. However, this is an issue of proof rather than pleading standards. The elements of standing are not mere pleading requirements, but rather an indispensable part of the plaintiff's case, and therefore each element must be supported in the same way as any other matter on which the plaintiff bears the burden of proof, i.e., with the manner and degree of evidence required at the successive stages of litigation. And that's from Lujan 504 U.S. at 561. For example, a foreclosure plaintiff may satisfy pleading requirements by simply alleging that it is the holder of the note without attaching any additional documentary evidence. And then in bold I have, emphasized. But when a defendant subsequently raises the defense that the plaintiff lacks standing to foreclose, the plaintiff must then prove that it held the note at the time of filing. Okay, so then I go on in my part of the writing. Here, the defendant, Klein, raised the defense that plaintiff lacked standing because it could not produce the note. Wells Fargo took the murky step of filing a false affidavit of lost original note on July 19, 2011, rather than showing proper candor to the court. Then a new paragraph. Another indication that the court meant one in the sense of singular is its agreement with the Vermont Supreme Court. And then I quote from Deutsche again. We agree with the Vermont Supreme Court, which opined that it is neither irrelevant nor wasteful to expect a foreclosing party to actually be in possession of its claimed interest in the note and have the proper supporting documentation in hand when filing suit. Kimball, 2011, Vermont 81, paragraph 20. Okay, scrolling. I can understand if you're bored and give up on this, but the point is, it's really hard for me to understand how courts around the country can take American homes from families and put them into corporate ownership. I mean, kids are on the street. People are living in tents. And banks have made record earnings, and lawyers, surprisingly enough, have had the best year ever. I wonder why that is. Okay, so since the note, this is me writing, since the note was lost in 2002, and supporting documentation showed this, Wells Fargo was required under the UCC and Deutsche to file the case saying that the note was lost. The fact Wells Fargo chose instead to dissemble could be explained by the fact the mortgage was not assigned to Wells Fargo until July 1, 2005, almost 3 years after the note was last seen in September 2002. This also could explain why Wells Fargo chose not to serve me its complaint for foreclosure, since if I did not know about the case, I could not fight it, and a default judgment would eliminate any problems with proving standing. To me, the lack of service raised a red flag. Okay, then I go on to talk about appellant's brain injury, because I have this idiotic, irritating brain injury. Appellant's brain injury disability under the ADA is the title of the, series of paragraphs. Perhaps this court and the appeals court misunderstood what I wrote, because I don't write as clearly as someone without a brain injury, much less as clearly as a lawyer. If I could have raised the money to hire Karen Friedman, I would have, but my GoFundMe raised only $1,615 of her $10,000 retainer. She very kindly helped me on a pro bono basis with my notice of appeal, but she could not take my case without being paid. I'm looking to see how long this is. I think it's getting to be too long. Okay, so then I go on to talk about my neurological evaluation, because I've lost more than half of my processing speed, which you would think would make it take twice as long to do things, but no, it takes much, much, much longer. I don't know how that can be, that having lost half my processing speed, it takes 10 times longer to think. I don't know why that is. I don't know. Testing maybe is not adequate, or maybe the results aren't correlated to whatever. Okay, so here's the point. Obviously, I don't want you to continue to send me money, because I'm not trying to hire a lawyer anymore. They're just too expensive. There's no way I can. And besides, the last lawyer I hired, the one who represented me in the trial, he was just atrocious. The lawyer I wanted to hire is a good lawyer, and she would not have been atrocious. But overall, she thought the whole case could have cost $30,000. Ha ha! So, not happening. I don't have the money. And I think that I've stated it clearly. I want you to understand that the point is that at the time Wells Fargo filed, or any foreclosure plaintiff files a complaint for foreclosure, they need to establish standing. And one of the things they have to do is, under the UCC, choose one of the three categories. Do they hold the note? Do they not? Do they have the rights of a holder, even though they don't have it in their possession? Or they can choose lost note. So if they choose to attach a copy of the note to the complaint, as if they hold the note, but then it turns out later when you ask to see that note, they don't have it. They don't have standing, because they did not establish standing in the beginning. This should be so easy to argue in court and win, but no. If my Supreme Court doesn't even uphold its own written words, no wonder all these homes are going to corporate ownership. Thank you for listening. wish me luck.